Hi, my name is Tim JK again, and small business topics on my channel. We're going to talk about bankruptcy. Bankruptcy. Think of that in your back pocket and kind of keep that in mind. We're getting ready to go through um, another probably recession, and because of the recession, you need to be prepared, just like you do a succession plan for your business. You need to be prepared what happens in the worst case scenarios financially for your organization. And you need to be really prudent in that in order to protect you and your employees and your company. There's things that you can do, and bankruptcy is one of those options. Maybe it's the last resort, but sometime you have to do it. Let's jump right into it. Of course, there is personal bankruptcy and there is commercial or small business bankruptcy. In a nutshell, bankruptcy allows you to, number one, as a Chapter 13 for personal, is to reorganize your debts and reorganize your debts so it's affordable to your payment of your income. Some things might have to be crammed down. This means if you have a car, the value can be brought down, and other debts can be brought down to make sure you are able to meet that budget. So sorry about that, kind of keep that in mind. Number two, you can liquidate everything and start over. And let me caveat this one thing about personal credit. Yes, you would have this on your file for personal credit technically for 10 years, but there's a way for you to get this off as well on your personal bankruptcy. Okay. You can file if you have an LLC, you can file that um, part of your company as you, the person, and the company itself, because you may be the only single owner, and some things might spill over. Um, and a seven is all or nothing. You file it, and the chips land what they may, and the things that exempt is yours. And what does that look like for Chapter 7? Chapter 7, pretty much you do a creditors meeting. Uh, that's mean the creditors are notified. And they never show up. They have, usually 45 days out, and they can come in and scrutinize you, but it doesn't really mean anything. It's more of a waste of time. It's a finality. Uh, it's a formality that the trustee is also involved and runs the hearing and question you on certain things and does his report and turn to a court. Then you have a hearing with court, and that's it. You probably appear one time, and then within that 90-day period, the judge discharged a debt, and from that debt, your credit is erased, and you have no credit, and you start literally over. Only thing that's on there is all your bills has zeroed out, or pretty much, are showed as paid, and all the credit history is expunged because you start over on your credit report. In 6 months, you can be back at a 700 or 650, and 15 months later, a year later, you can be back at 800. Um, Business is a little different. Um, Personal is more consumer friendly. Business is more creditors friendly. Let me put a note here. I am not a bankruptcy attorney. I am not giving legal advice. I'm just telling you some scenarios to prepare your business as a business advisor. So again, I'm not giving you legal advice. I'm just telling you some scenarios or things that I have run across in really since the 80s that a lot of small business had to go through. And I've been through a lot of recessions. Let's talk about the chapter. Talk about business. When it comes to business, is a different story altogether. In business, it's creditors is in charge here. The only thing that you have going for you, if you're Chapter 7, you just liquidate all the assets and call it a day. You don't have to do anything. Um, you emergency file just like you do personal. You can stop the creditors that moment, um, and that's it. If it's an 11, which I'm gonna go through, 11 is a little different. The creditors are in charge. So if you don't like your creditors before the bankruptcy, you're not going to like them during the bankruptcy. So some businesses will set up several LLCs way in advance. We're not talking about in the last 60 days because you have to disclose that. You want to do that like a year in advance, or do that when things are really, really good, and put certain things in certain assets. Hey, you want to have your lease under this, you want to have your equipment here, you want to have all your assets split up the same way that you would do a in real estate when you do a house or a grouping of properties in an LLC. That liability cannot spill over to the next. Also, you're going to look at a minimum of $25,000 to file a Chapter 11 reorganization for your business. And I mean, that's the minimum. Yeah. These things are very expensive, very time consuming, and very tedious for an attorney. You got to make sure that you get an attorney to work with you on this and have experience in dealing with Chapter 11. Some of them have never done it, they just done consumers. Most cases in these debt remediations, they fail. The majority of them fail. That's even for the consumer, unless they're doing a 7, is really clean, is over. And if they do a 13, most of them fail. The same thing with Chapter 11. Most of them fail with the business unless they have a lot of assets that they can work around. Minimum $25,000 and goes up. Lots of paperwork, probably this thick. A lot of disclosures you have to make. So if you have everything in different LLCs, those LLCs still protected. Some people will lease their own equipment back to them and put it in a different LLC so they can have access. Or if I need to liquidate the business and move into another business, I can bridge that as well with the clientele and everything else. So let's kind of look through the slides real quick. Again, I'm not giving legal advice. I'm just giving you what I already know and have experience with in business consulting. So I'm gonna use this slide here, and you can kind of reach out to these people as well. This is not the actual slide I was going to use, but this is fine. It has some of the information. An intro. And again, thanks for being here and tuning into this little session. And basically, bankruptcy is a protection for employees. Is to be able to renegotiate your debts with your landlord, your employees, your suppliers, and also change your operations for the good or the bad. Banks. So that's really what it is. If your landlord locks you out, do the bankruptcy before they lock you out, because it's a lot easier to show that I'm sorry I filed bankruptcy before. Now, once you file bankruptcy, you can't get uh, access back into the property. The attorney will have to call the landlord to let them know that that debt now goes into the receivership of the court, jurisdiction of the court, and they have to let you back on the property and you start over. But you got to make your and from that point on, you still have to make those payments and above. So if you owe $1,000, um, back up. If you owe $50,000 in previous debt, that's on hold because now it's in jurisdiction of the court. But you had to make your current payment with your landlord on that payment. So it starts anew. The same thing with suppliers and everything else starts anew. Now it's up to the suppliers if they want to grant you another line of credit. If it's something significant and they know you're good for it, they will probably work with you on that course because they still want the business. Your operations will change. You might have to scale down, but at least you take care of a lot of debt. If you look at the General Motors bankruptcy, it was done really quickly, intervened by the government, and they just Chapter 7 it and worked it back out and cleaned all the debt up and renegotiate with the suppliers. So yes, it's life after Chapter 7. You can start a brand new company. Is it worth more than the bankruptcy? Sometimes it costs more to try to keep a company alive than just to let it sink and start over. Remember, this is America. You just start a brand new company. It's not all about that. Yeah, if you have some things that branding, start over. start a new brand. If you're good enough to start this company, start another. Take the information, take the assets of the other company, and go from that. Now you might have like a brand of the company, and you might have which is the name, and you might have the assets of the company. So like Toys R Us has the brand. Someone bought the brand of name of Toys R Us, and they can start over, and because they have the brand was probably sold, but also you can keep that in a separate entity and license that to your existing company as well if you're so stuck on the brand, and the brand can live again because you may be personal owned. It's like Popeyes. He owned the recipes and he changed the recipes. He refused to use his recipes at the very beginning, which was, I mean, those biscuits were insane. Um, and he redeveloped what he wanted the restaurants to have because he know that things were pretty bumpy and shaky. And Popeyes finally did go to bankruptcy. Bankruptcy is a social safety net. It's a constitutional right. It helps business at a vulnerable state to get restructured out of fairness and to be able to get back on their feet because they're not looking at the business viability of being economics for the area or employers. They look at the whole thing that the impact is making for the economy and of that city and the economy of keeping those employees employed. So it's a lot of things that bankruptcy does that protects the company, but as you, as an owner or the main owner of the organization and directors, need to know when it's time to just fold them. Sometimes it's the case, and you can just start over. So it's not really that bad. It doesn't have the stigma as it used to. Again, like I mentioned with credit, you can even get that off your credit report with a good credit repair agency. So nothing is in stone forever. Keep that in mind. Uh, Mentioned earlier about the two bankruptcies in business, there's a Chapter 7 liquidation where you're going to just close the business and auction things off. The trustees take over and you do absolutely nothing. You might want to take your personal things out because once the trustee has the judge sign for it, if there is an office that they have need to access it, they get a signature from the judge, and the landlord has to give the trustee access to the property and the key to the property. And until the trustee finishes with that, um, uh, there's nothing the landlord can do. But the landlord is in first leaning position, like government entities, to get the benefits of the sale of the auction. So they might not get their full payment, but they'll get something out of it, since they actually storing the equipment and um, pretty much they're paying for storage. They get a percentage of they rent back. And in some cases, they can charge for storage if there is enough money out there that the trustee feels that out of fairness they can store them, or the trustee can get a moving company and move everything into storage in that case, if it's too much. It's better positioned that the landlord works with them unless they have another tenant need that space for something. So they can get something out of it and maybe get rental fees from just for storage. Reorganization, that is when the creditor is pretty much in charge. You have to negotiate with the creditors. You create a plan of organization. It can take you can, if it takes a year or two, some 3 years to do a complete plan of organization, and if the creditors don't like it, they can vote it down, and you're going to keep going back and forth. And this can last for a long time. So the judge gets tired of it, the court gets tired of it. Creditors get involved to vote on the plan. The majority gets rules, but basically it is what it is. I mean, the owners really don't have any say because you're in bankruptcy. Chapter 11 does work, but you would really need to have a plan out with a lawyer in advance on how you're going to strategize that. Could you identify the businesses have used Chapter 11? Airlines is a no-brainer. Chicago clubs, Hertz, General Motors, Marvel, Entertainment, Six Flags, Texaco, all of the above have filed for bankruptcy to shut off debt. Bankruptcy failure in many circumstances, especially in COVID-19, Chapter 11 is a backstop to prevent shutting down firms that are really viable. And if you look at COVID, that was a different story. It's a different story when you can't be in the same room with the other person because of COVID. That becomes people had to figure it out, and a lot of them had to take months to figure out how they going to work because the shutdown was pretty quick. You didn't get much notice. You've seen things come down the pipeline, but it was actually shut down within, to say, hey, we're shutting down like now. You didn't get much notice now, a week notice. You only got like a day notice. You really didn't even get a day notice. They just saying, hey, we're shutting down, period. Because they want the liabilities of people getting sick in these government agencies, and they did, they want to kill everyone. So they shut down. So, but for businesses, it was the same case. You didn't have that safety net. So bankruptcy are not failures. It's just you're just refocusing the organization to be better and anew. Historically, Chapter 11 has not worked very well for small business because of the high fees, complex voting rules that doesn't matter for small businesses, and it's hard for owners to keep the company. In February of 2020, the Small Business Reorganization Act, especially for small business, this was less than 7.5 million in liabilities. Makes it easy for small business to survive the process and for the owner to retain control. The judges usually will kind of um, facilitate that. So judges are kind of, you know, sympathetic because they want the employees not to lose their jobs, but they're gonna, they have to do common sense as well, and be common sense in the approach of what they allow. Regarding the 11 debtors, corporation partnerships and individuals who can be it. You can be an individual doing 11 uh, because it's tied to your business in a sense for a reorganization. So LLC or whatever is something that, you may be a sole owner or a sole prop. You can do an 11 and you have a little bit more control. So some Chapter 11 tools are automatic stay, which means that once it's filed, it's an automatic court injunction that no one can take action of collection. They cannot, um, they cannot take your property at that point. I mean, you have a person at the door getting ready to come in and automatically filed with the court electronically, which is done these days, or stamped uh, these days, that it stops at that moment. You cannot do anything. And then your attorney can go in if something is garnished or whatever, go in and let those people know on your bank account, or the bank who froze your account, or IRS who froze your account, unfreeze it because you're now in bankruptcy jurisdiction. You have a stay in effect, and they have to honor the stay. If not, they're going to have to deal with with the judge on that, and that's not, they understand they can't. Um, the judge can send the constables, can send the police after them if they don't comply, and can put them in contempt of court. So these are really serious. When these stays happen, is on the court jurisdiction at that point. Um, Debtors in possession of control. You can be in possession of the asset and control the assets and continue to operate your business. If you have a printing business and they try and pull the equipment, they had to stop, not pull the equipment. You still can operate while this plan works out. Now, you might not have to pay no rent for the equipment financing for that during that period, but you're in control and you're still operating until something gets approved and worked out with the trustee and the judge. You reject, burdensome leases. If you don't need the space, like in COVID, you can get out of it, and that's stripped out of the plan itself. If you need to downsize, then you can downsize as well. Sell all or part of the business. You can do that. You can liquidate your fleet, the trucks, or whatever equipment that you need in order to bring money into the organization. You still can obtain financing with the court's approval. So that's available as well. You can reduce your unsecured debt like credit cards. American Express can't do anything as well. You can reduce it. Is up to them if they want to grant you more credit. Rewrite mortgages and secure debt. You can renegotiate the terms and restructure the debt and resolve all the claims in one form, which is this. It does not work, Chapter 11, if you for a small business. If it's too expensive, it's too cumbersome, confirmation standards are too difficult, creditors are too apathetic, and absolutely priority rules. This means that the priorities like the landlords, the IRS, the government agencies get theirs first and nobody gets anything. So it doesn't make anyone happy. Now, you can keep in mind when you get an attorney, make sure you interview them well. Make sure they have experience in dealing with business. They might have consumer bankruptcy experience, but some of them don't have really business bankruptcy experience. Make sure you get a business bankruptcy attorney. It's going to be expensive, but you have to have one. In addition, um, unlike the personal, you can file pro se. This means you can represent yourself. You cannot represent yourself when it comes to a business bankruptcy. You have to have an attorney because it's cumbersome. Dealing with trustees, dealing with creditors, uh, dealing with the creditors meetings and all of this stuff. You are required to have it, or not, they'll dismiss your case. Is no way to get around it. But for a seven, even for a seven, you have to do the same thing. Absolutely priority rules. You have to have the priority, is going to have the rule. If you can't meet the high voting requirement, 2/3 in the amount and majority in the number, must pay creditors in full if you cannot meet it. Okay, you must pay the creditors in full or give up ownership of your business. Requirements for the small business to be a subchapter 5 debtor must engage in commercial business activities. Not less than 50% of the debtor's debts must arise from commercial or business activities. Debts cannot exceed, as of March 21, $7.5 million. Okay, is really almost triple, but it's really no two and a half times. It's about 2 times than it was before. So what it may not be is a single asset real estate owner. So you can't just own one house or one building. Uh, so you got to have more than that. A member of an affiliate group, aggregated debt 2.7, or really is 7.5 now. Public trading company and affiliate of a public trading company. And the reason I say that because you can raise money on as a publicly traded company with investors, even if you bankrupt or venture capitalist, if it's a good company, because you still will have stock. You can still go back to if it makes sense. You can do a lot of things legally that you need an attorney can help you with to raise funds. So it's not totally out of the picture. Important characteristics of subchapter 5. No absolute priority rule. Okay. You have the subchapter trustee. You have only debtor may file the plan, and you must have plan must be filed in 90 days. So that's really is a good deal. It's a simplified method requirement than doing this full thing of here, absolute rule, this chaos with chapter 11. The statute that's put here makes things a lot easier to navigate for a smaller business. Documents must be filled with the bankruptcy petition, balance sheets, okay? Statement of operation, it's a P&L, cash flow statement, and income tax. Income tax is going to be important. Now, when you file, if you do an emergency filing, and that can be on the weekend or whatever, or after hours or during the daytime, they give you a certain amount of days to turn that in. So I can't remember offhand, is it 3 days or 5 days or 7 days? Is one of that within a week that all this information has to be uploaded. Your debtors list going to have to be uploaded within a few days because they need to notify them that you filed. So I know that's first. The others, they might give you 7 days to file that, or 14 days to file the other information as your balance sheet and all the things like that. But the creditors is going to be probably the first thing that you need to file right away, because they have to notify the creditors from the court in writing that a stay is there and they can collect on their debt. The goal is to get a consensus of the plan. They may everybody agree. Debtors gets a discharge at the end of confirmation plan, and trustee terminates the confirmation. Okay. So confirmation is when everybody's agreed and everything has been paid and you're confirmed. I mean, no, take that back. Confirming the plan that everybody agreed to the plan, that this is the way to go. Creditors agree, trustee agree, courts agree, and it's filed and it's confirmed. Okay. And the trustee terminates at confirmation. So when you confirm your plan. So you can confirm in both ways, even with the 13 is confirmed. Okay. A cram down is like, for example, if I have a $60,000 car and it cannot fit in my payment and the market value is 30,000, I can cram it down to the market value is 30,000 in order to make my payments fit where I need them to fit. Of course, they're going to yell and scream. And I think that was one of the issues in the previous bankruptcy reform before 2007, I believe it is, or 2005. 2005, going to six, that people cram down their cars for almost nothing, and they buy a brand new car and file bankruptcy in 2 months and cram it down. So they got this new Cadillac or Mercedes for 50 something, $60,000, and cram it down to 30 to make the payment fit in their plan, or 20 and is agreed to. You can do this as well, as long as in your plan as well. So it's a little harder today, but if it makes sense in order to keep the business afloat, then it is what it is. Projected disposable income. If anything extra, you give it out to you pay your plan, and you pay your debtors. So you have to pay an administrative fee to the trustee. It's a percentage, 2 or 3%, 1%, and whatever that amount is. It's not gonna be that much, or maybe 1 to 2, 3%. Will go to the trustee. Filing fees will go to the court, and that percentage that's paid every single month goes to the trustee for all the administrative things that they do for your case, and keep tabs on you. And if there's a lot of money left over, in the reasonable amount, if it's $100 left over, they're not going to worry about that going to it. They'll say, okay, if you get $100 left over, it's not worth dealing with that, collecting that and sending it on, because you might lose income or whatever. But if it's something significant, $5,000, $10,000 or whatever, they might say, hey, let's pull $1,000 to go back to the creditors. Can the plan be crammed down over objections of the plan? Creditors retain the lien, lien position is mean title, and secure the claim until the claim is paid in deferred cash payments equal to the value of the collateral or the collateral sold. Or another thing, it says secure creditor realize that they're just not going to get it. So they still have a claim on it, but as the plan closes down, before you get to discharge, they have an opportunity to object to that discharge, and you guys come up with some payment that's done before the discharge, because once the discharge, this is yours. So if they didn't object to it, the discharge, over their land or car or whatever, then game is over. You got it. Because once this discharge happens, the debt is clear. An example of a cram down claim is the debtor owes an office building with a mortgage of $1.4 million, but he owes $1 million. Write down mortgage to $1 million. Okay, we cram down 400,000. The creditor retains the lien for $1 million. The creditor has an unsecured claim of 400,000, which will probably get discharged. And the 1 million mortgage claim, once it's paid off over time and with market interest, is yours. But if they don't do anything, then it's going to be yours. Real estate people are usually on top of it. There's other creditors who just don't want to be bothered with. Okay, two ways to cram down a plan over the injections of unsecured creditors. Um, One, pay project disposable income to 3 to 5 years, term to be determined by the court after the debt or gets a discharge, and give the balance is forgiven. Okay, or pay the other property having the value of the equal confirmation amount that was already agreed to, and that's it. Is secured. So once the discharge is over, sources of funds to pay a lump sum to creditors at exit financing. You can get owners, 501k, wealthy aunt, or a new investor. So you can take these one lump sum. Some people will buy properties or pick things apart in the bankruptcy what they want. So it's like an auction house. Hey, I want to buy this from the bankruptcy. Um, the creditor don't want it. I mean, you have all this stuff in your office. No, Quill doesn't need to take their office supplies back. You can have them, and someone else can buy it, or just what it really means. They can buy this stuff because creditors don't want to pay for it to get it back, whatever it is, unless it has some type of value. Things to consider. Subchapter 5 is voluntary. There is no automatic rights to dismiss. Case moves pretty fast, so things are kind of expedited. Starting to plan early before filing. Make sure you line up your financing in advance. Start drafting your plan. Line up your creditors' support because you need nice creditors to approve your plan. Gather your balance sheets, your balance sheet, income statement, a cash flow statement, income tax returns, and your calculated projected disposable income. That needs to be done way in advance. When you know that the ship is sinking, start preparing this stuff right away, 60 days out, so you can give it to their attorney at the start of it. It makes life much easier. Then they know what they can work from. Automatic stays for Chapter 11. That is the tool for in 11. Everything stops. The debtor in possession has the control of the equipment and the business. Rejection of burdensome leasing, like you own a lease in Park Avenue. That's, you can get out of that and move. Set all a part of the business. You can start selling it. And also you can take financing as well. There are debtor in possession financing available. There's a reduce your unsecured debt, like credit cards or lines of credit that you have at different vendors. You can rewrite your mortgage. You might do a balloon note at the very end, and other secured debts. And you can resolve claims in one form. Okay. So we're going to take a quick poll. Other than this is kind of include this part of the video, but all the other stuff that really doesn't matter. It's mainly stats that we use. So in conclusion, the new bankruptcy law is important development for small business. The lack of information, stigma for bankruptcy are really important barriers. If you file bankruptcy in your business is pretty much dead, unless you're a mid-sized business, $5 million or above, that have money and assets that you can still operate. But if you're a small $1 million operation, you're dead in the water. Just start over. So other than that is my information regarding bankruptcy today. Thank you for tuning in. Please like and share. You have any comments? I can't give you a lot of stuff on bankruptcy. I have friends who are bankruptcy attorneys. But what you can do is put your comments if you need to be, and I can get the answers for you about this slide. If you want the slide email to me, just email me in the form and I'll send it. Please like, share, and subscribe. Thank you for tuning in. Tim Jacquet.